All right, Ms. Wilson, how are we proceeding?
I believe Mr. Lee is ready on Adams.
Who's covering Ms. Adams? Oh, Mr. Lee. Didn't see Mr. Lee. All right, so we're on the record in docket 2402-372. That is people of the state of Michigan versus Shariva Adams. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Shariva Martika Adams.
And ma'am, you'll have to unmute. You are Shariva Adams, is that correct?
Yes.
All right, thank you. This is the time set. There she is. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe we're going to request a final pretrial.
And is that a fair statement, Mr. Lee?
Yes, Your Honor.
So we'll set this for final pretrial for September 9th at 8:30. So this will be set for final pretrial on September 9th at 8:30. Anything else for the record in 2402-372? Ms. Wilson.
Not for the people.
Mr. Lee.
Your Honor, Ms. Adams does have one other request. She inquired as to whether the court would be willing to allow her to work without a scram tether because she works at a home care service by Dawn's Early Light is the name of it, and provides her family's only income. She needs to be able to work, and they will not allow her to do home care visits and or be in nursing homes with a scram tether on. The complaining witnesses in this matter are 19-year-old and 21-year-old young men. Not sure that the tether is needed for their protection, but the scram tether may be in place for other reasons I'm not aware of.
Right.
That is her request.
Thank you. I have a scram tether. It's not a GPS. Was condition of release by Magistrate Milmore. Ms. Wilson, any comment?
Thank you, Your Honor. My review of the file, it did indicate that Ms. Adams was very intoxicated during this event. I'm not sure that there's an ability to, for her to take the tether off and put back on during work hours. Ultimately, I would leave it to the court's discretion. If we are going to remove the tether, I think it would be appropriate to have some kind of documentation for Ms. Adams' work that those statements are accurate.
Is the scram tether, was that put on because of the strong odor because of the alcohol consumption, or was it meant for the protection of somebody?
I'm guessing it was for the intoxication. Did we request it, or did
I can't tell from the notes if it was. There's nothing to suggest it's just a scram tether, not GPS.
We did request that she
Was
participate in substance abuse testing or monitoring. And I do believe it's because of the intoxication at the time of the event and the arrest.
I have that. I have. I have. So the scram tether is in place. Do not release on bond without scram tether were the instructions from Magistrate Milmore. So I'm going to deny the motion brought by counsel based on Magistrate Milmore's. That was indicated in no uncertain terms. Do not release on bond without scram tether. So without that condition, Ms. Adams would receive a different bond. So I'll deny the motion to release to remove the scram tether. Anything else for the record in docket 2402-372, Ms. Wilson?
Not for the people, thank you.
Mr. Lee?
Nothing further.
All right, thank you. You're all set, Ms. Adams. Thank you for your appearance today.
This is bullshit. I can't work. It's crazy. I don't know what the fuck we're gonna do. I can't even get out of this stupid thing. I'm gonna have to talk to one of them other judges or something because I can't. They not letting me on schedule. How the fuck am I supposed to go to work?
All right, so Ms. Woods, we'll call your case.
This thing ain't letting me fucking go.
I just saw him on video.
Gotcha.
All right, so we're on the record in docket 24-018-1815. Docket 24-018-16. And docket 24-018-17. People versus Sheila Woods. Will the parties please introduce themselves for the record? Ms. Wilson.
Happy to go for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office here to represent Ms. Woods, who's appearing over Zoom today.
And sir, you are Sheila Woods, is that correct?
Yes.
All right, thank you. This is the time set for a pretrial on these three matters. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Mr. Goodrich did inform me that Ms. Woods has received the license for all three dogs. The people would move to dismiss for compliance.
Is that a fair statement, Mr. Goodrich?
Yes, Your Honor. If you recall, the last time we were here, Ms. Woods stated she wanted to go to the fairgrounds for the Ingham County's matter to get dogs licensed. She did that, and she showed me each of the licenses over Zoom this morning.
All right, thank you. All right, so based on the prosecutor's motion to dismiss for compliance, I will dismiss orally and then sign are these on a ticket?
They're on a ticket.
Okay. I'll dismiss 24-018-17. People move to dismiss without prejudice for compliance. 24-018-16, 24-018-17, and 24-018-15. So 815, 16, and 17, all dismissed for compliance purposes. Anything else for the record in either one of these three files, Ms. Wilson?
Not for the people.
Mr. Goodrich?
No, Your Honor. Thank you.
All right, Ms. Woods, you're all set. These will all be dismissed without prejudice.
All right. Thank you.
You're welcome.
Yes.
All right. Who's next, Ms. Wilson?
Casey Erickson, she has 3 files.
Erickson, can you start your video, please?
Thank you. All right, so we're on the record in docket 24-01913. 24-01913, 24-01914, and 24-01915. That is people in the state of Michigan versus Casey Erickson. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Goodrich.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Ms. Erickson, who is appearing over Zoom today.
And ma'am, you are Casey Erickson, is that correct?
Yes, Your Honor.
All right, you can hear me all right, Ms. Erickson?
Yes.
All right, thank you. This is the time set for a pretrial on the matter. Ms. Wilson, how we proceed?
Thank you, Your Honor. It's my understanding that Ms. Erickson has obtained a license for 2 of the dogs and has obtained vaccinations for 1 of the dogs and plans on getting a license after her next paycheck. Given those representations, the people are prepared to dismiss all three without prejudice
For
for
compliance.
compliance, yes.
Okay, thank you. Mr. Goodrich, is that your understanding?
Yes, it is, Your Honor.
All right. So, and they're all written on tickets.
They should be.
All right, so based on the prosecutor's motion, I'll grant the motion. And the prosecutor is moving to dismiss without prejudice for compliance purposes. That'll be in 24-01913. Prosecutor moves to dismiss without prejudice for compliance purposes. 24-01914. And similarly in 24-01915. The prosecutor moves to dismiss without prejudice for compliance. So, Ms. Erickson, you should be all set. The people have moved to dismiss all three files without prejudice for compliance purposes. Anything else for the record in any of those three files, Ms. Smith?
Not for the people, thank you.
Mr. Goodrich?
No, Your Honor, thank you.
You're all set, Ms. Erickson. Thank you for your appearance today.
Thank you too, Your Honor.
Katrina Sturrock. She's at 9 o'clock. No. It's sure.
Because that on the sign stuff.
Okay.
So. I don't think anything in place.
Right.
It's kind of.
But it would be a problem.
I told her that, you know.
All right, Ms. Wilson, how are we proceeding?
I think we're ready on Van Atten.
Anthony Van Atten?
Yes.
All right, so we're on the record in docket 24-02385. That is people of the state of Michigan versus D'Anthony Van Atten. The parties please introduce themselves for the record. Ms. Wilson.
Abigail Wilson for the people.
Ms. Nickel.
Tara Nickel from the Ingham County Public Defender's Office on behalf of Mr. Van Atten. Mr. Van Atten is appearing on Zoom.
And sir, you are D'Anthony Van Atten, is that correct?
Yes, Your Honor.
Okay, and you can hear me all right, Mr. Van Atten?
Yes, Your Honor. I'm just outside because I was waiting at the bus stop because I'm going up to the hospital to see my daughter. My bad.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a request for an adjournment of the pretrial for further negotiations.
And is that a fair statement, Ms. Nichol?
Yes, Your Honor.
So we will adjourn the matter for further negotiations. It'll be adjourned to
September 9th at 9:30.
September 9th at 9:30. Right, we've adjourned this matter for continued negotiations for pretrial for September 9th at 9:30. Anything else for the record in 2402-385, Ms. Wilson?
Not for the people.
Ms. Nichol.
No, Your Honor, thank you.
All right, Mr. Van Anden, we'll see you on September 9th at 9:30. You're all set.
Are you
sir.
guys gonna be sending the Zoom information to my house?
It'll be sent, the Zoom information will be sent to your last updated address with the court.
Okay, thank you.
You're welcome.
Have a good day.
Is there any updates on whether Wilkins was brought?
They're going to check right now.
Okay.
We have Drum on Zoom. We have Sturrock on Zoom.
I believe we're ready on Staley.
On
if
Staley?
somebody's here.
Staley here.
Miss Villanueva.
Okay.
And I'm ready on Sturrock too.
Which one do you want to go on?
Let's start with Staley.
All right, so we're on the record in docket 24-01714, 24-01715, and 24-01716. That is people of the state of Michigan versus Tony Staley. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Tony Staley.
And ma'am, you are Tony Staley, is that correct? All right, thank you. This is the time set for a pretrial on all three files. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I have received information that one of the dogs is deceased. The other two dogs, it's my understanding Ms. Staley is still working on getting a license for. I'm trying to find which case is the dog that's deceased real quick.
All right.
In case number 24-01714, and that is in reference to dog Celine. That dog is currently deceased, so the people would be moving to dismiss.
All right, so in docket 24-01714, that file is dismissed pursuant to the motion made by the prosecutor. And then on 15 and 16,
I believe we're going to be requesting an adjournment so that Ms. Daly can get in compliance.
Mr. Lee.
Concur, Your Honor.
So this would be the second adjournment for compliance on these cases, on these two files, 15 and 16. I will grant the adjournment, but this will be the last adjournment. We'll set for, and a lot previously it was about 30 days, right?
Yes, sir.
That's what it looks like. So let's make it 30 days out. So September 23rd at 9 o'clock. All right, Ms. Staley, these have been adjourned to September 23rd at 9 o'clock for compliance purposes. Any information you receive, make sure you forward to Mr. Lee so he can make sure that the prosecutor has any paperwork in advance. Anything else for the record in docket 24-01715 or 16? Ms. Wilson,
Not for the people.
Mr. Lee.
Nothing for the defense, Your Honor.
Okay, Ms. Staley, you're all set. Thank you for your appearance today.
Thank you.
Drum and Sturrock are on Zoom or
I believe Miss Villanueva.
Villanueva.
She's been here since like 8.
Sonia.
Yeah.
Right, so we're on the record in docket 24-00559. That is people of the state of Michigan versus Sonia Villanueva. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Sonia Villanueva.
Ma'am, you are Sonia Villanueva, is that correct?
Yes.
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a request for an adjournment for compliance.
Is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
So we'll reset the pretrial for compliance purposes for 30 days. September 23rd at 9 o'clock. So Ms. Villanueva, make sure that Mr. Lee has any paperwork that he may want to advance to the assistant prosecutor. We've reset this for September 23rd at 9 o'clock. All right, ma'am?
Thank you.
Right. Anything else for the record in 24-00559, Ms. Wilson?
Not for the people.
Yeah, Mr. Lee, you have anything else?
Nothing further.
All right, we're all set. Thank you for your appearance today.
No, he needs to-
Yes.
You should.
Ms. Wilson, who did you want to call next? Katrina Sturrock is on Zoom and Brandon Drum is on Zoom.
Okay. Okay.
And then Mr. Wilkins, I'm assuming, and Mr. Wirt.
Yeah, looks like it's-
Did we ever do a final pretrial on Parker?
I think today was supposed to be the final retrial.
Okay. Still have that one too.
Mhm.
She's not gonna be here.
She showed up.
What's your name?
I'm not around. Yeah. I think we're already on Sturlock.
All right. Sturrock. All right, Mr. Rock, we'll call your case. You can unmute. There you go, ma'am. So we're on the record in docket 20-1048. That is people of the state of Michigan versus Katrina Sue Sturrock. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson with the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Katrina Sturrock.
And ma'am, you are Katrina Sturrock, is that correct?
Correct.
And you can hear me all right, Ms. Sturrock?
Yes, sir.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I believe this is going to be a request for an adjournment for negotiations.
As we continue negotiations. Is that a fair statement, Mr. Lee?
Yes, Your Honor.
So we'll set this probably at the same time we've been using.
I would think.
Earlier or later? Since you're gonna earlier?
September 9th at 9:30.
September 9th at 9:30. All right, we've set this pretrial out for September 9th at 9:30. Anything else for the record in docket 20-1048, Ms. Wilson?
After the people.
Mr. Lee.
Nothing for the defense.
All right, ma'am, we've set it out for September 9th at 9:30, all right?
Thank you, sir.
You're all set. Thank you for your appearance today.
Yep.
Yeah, so we can get them cleared out.
Let's do it.
Yes, yep. Is there any indication of whether or not Sue's work is going to be on Polygon?
But not listed in testing that I'm aware of.
I don't have, so I don't have anything
I believe
indicating.
he got released.
Oh, okay.
I can check the list just to confirm.
Okay.
He has 2 licenses in hand.
Okay, let's go. We're ready on Philip Cole.
Philip Cole.
There should be 2 files.
And here in person.
Okay, sweet, thank you.
All right, so we're on the record in docket 24-02058 and 24-02059. That is people of the state of Michigan versus Philip Cole. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Cole, who is standing to my right today.
And sir, you are Philip Cole, is that correct?
Yes, you are.
Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how we proceed?
Thank you, Your Honor. Mr. Goodrich did just show me 2 licenses that the defendant has provided. The people are moving to dismiss for compliance.
And that's a fair statement, Mr. Goodrich.
Yes, it is, Your Honor.
All right, so I'm in, so on record 24, on docket 24-02058, the people move to dismiss without prejudice for compliance purposes. That is granted. I'll also on 24-02059, the people move to dismiss for compliance purposes. I will grant that motion and dismiss that file also. So that should be on 24-02059 and 24-02058. Anything else for the record in either one of those files, Ms. Wilson?
Not for the people, thank you.
Mr. Goodrich.
No, Your Honor.
All right, Mr. Cole, you should be all set. Thank you for your appearance.
So, if you're nobody.
Yeah.
What are your thoughts on that?
I mean, I never told her, so I should do what's moving forward, so. yeah. Are you ready on him?
Sure.
Okay. Sorry.
Which one is that?
Jeremy Parker, that was 8:30.
All right, so we're on the record in docket 22-00140. That is People of the State of Michigan versus Jeremy Parker. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Parker, who has not appeared today.
All right, this is the time set for a final pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. Mr. Parker is not present today. The complaining witness was also not present. It appears that we had some mail that was returned from her for a bad address. I have not had the opportunity to try to call her to get a new address. As Mr. Parker also failed to appear, I'd be requesting the bench court with a 48-hour hold.
All right, Mr. Goodrich.
Your Honor, considering that there doesn't appear to be any witnesses on the case, we would ask the court to just dismiss the matter at this time, as it appears it's not going to go forward.
All right,
Most likely.
my understanding, this is an older case. But Mr. Parker was here on August 5th, 2024, in which this was set today for final pretrial. It appears that the victim in this matter, we're not sure, do we have an updated address?
I have not been able to call her to try to get one. It looks like we made contact with her back in 2021 or 2 when the case was initially filed, but I admittedly dropped the ball and wasn't able to call her ahead of today's hearing.
All right. So Mr. Parker's supposed to be here anyway, and he's not. So I'm going to issue so defendants failed to appear today. He was here 2 weeks ago when we set this. So bench warrant and bond forfeiture is issued. Because of the age of the case, I'm going to issue it with a 48-hour hold. And then that should give time, Ms. Wilson, for you to update the
Thank
subpoena
you.
list.
I appreciate it.
Anything else for the record in docket 22-00140, Ms. Wilson?
Not for the people.
Mr. Goodrich?
No, Your Honor.
Thank you. All right. Who's next, Ms. Wilson?
Were we ready on? Wilkins? Wilkins?
Okay. It's around the record in docket 22-02865. That is People of the State of Michigan versus Gerald Wilkins. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Gerald Wilkins.
And sir, you are Gerald Wilkins, is that correct?
I am, sir.
Okay, thank you. This is the time set for pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It's my understanding that this is going to be a plea to the charge. There is a sentencing agreement to time served. with restitution in the amount of $449.95 payable to the City Rescue Mission. It's my understanding that Mr. Wilkins just received a sentence out of Eaton County for 365 days with credit for 79 days. So it will likely need to be referred to collections for when he's released.
All right, and the time, do you have a number on the time served?
I don't, I suspect it's in the ballpark of the 79 days, but I can't be sure. I think we tried to figure it out last time and it was causing too much math.
How many days do we? Just a question. So, Ms. Wilson, is there any objection to immediate sentencing?
There's not, Your Honor. I would just request that in accordance with the Crime Victims' Right Act, the court would allow me to read the victim impact statement that we have on file into the record. I got, as of August 12th, was 1,010%.
He was paired a bunch of other times, so from August 7th to today. 19/7/26. Best I can do in the file.
On June 9th, it was 2,010%. What's that? 2023.
At 4 days. I paired them within 7 times.
Yeah, and what's the restitution on this?
$449.95.
$449.99. We'll put time served at 30 days. I'm estimating that, so.
Yeah.
All right, is that a fair statement of Mr. Lee? It is a plea to the charge, time served, which is 30 days. I've estimated at least 30 days, if not more or less. But at 30 days, at least 30 days, restitution of $449 that will most likely be referred to collections. And then if we go to immediate sentencing, I'll allow Ms. Wilson to read in the impact statement, the victim impact statement. Is that your understanding, Mr. Lee?
That is my understanding, Your Honor.
All right. May I go over the advice of rights with your client, Mr. Lee?
Yes, sir.
All right. It is, if you plead to the charge, Mr. Wilkin, you'll have the following trial rights. You'll be waiving these rights, all right? You have a right to be tried by a jury, to be presumed innocent until proven guilty. Have the prosecutor prove beyond a reasonable doubt that you are guilty. To have any witnesses against you appear at trial. To question any witness that are brought against you. You're represented today by Attorney John Lee, and he'd be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. You have the right to have the court ordering witnesses appear in your defense, remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. You understand your misdemeanor jury trial rights, sir?
I do, sir.
If your plea is accepted, you'll give up the claim. The plea was a result of any promises other than what's been placed on the record or threats. It was not your choice to plead guilty. You'd be giving up the right to appeal any issues from an actual trial because you won't be having a trial. You'll be pleading to the unlawful entry instead. Is it your wish today to plead guilty to the unlawful entry? Okay. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I'm going to bring your attention back to July 3rd of 2022 at the offense location of City Rescue Mission located at 601 North Larch in the city of Lansing, Ingham County. Were you present at 601 North Larch on July 3rd, 2022?
I will.
And at that time, did you illegally break and enter without the permission of the city rescue mission? Any permission from that agency?
I did.
Okay. Was that occupied or unoccupied at the time?
Unoccupied.
And you did so intentionally?
Yeah.
All right, thank you. Anything towards a factual basis, Miss Wilson?
Not for the people, Your Honor. Thank you.
Mr. Lee?
Nothing further, Your Honor.
Okay. I find the factual basis to be knowing, voluntarily, and accurately made. I will continue with the agreement. Time served for 30 days. Any restitution to be referred to collections on this matter. So that's a $449.99. Ms. Wilson, would you like to read any impact statement into the record?
I would, Your Honor. Thank you. This is the impact statement provided by Richard Burton, a representative of the City Rescue Mission from August 28th of 2022. The City Rescue Mission's goal is to provide food, shelter, and hope to Lansing's homeless. Each year, City Rescue Mission serves thousands of homeless guests without any government substitutes. When an individual forces entry, squats, and vandalizes our property, it is a mockery of our generosity and shatters our sense of security. We strive to serve all our guests with dignity and respect, but feel greatly disrespected and taken advantage of by such lawless acts. The City Rescue Mission wishes to have any and all expenses reimbursed, along with any rehabilitative measures necessary to restore Mr. Wilkins to being an upright citizen.
Thank you.
Just a little bit more.
Okay.
Due to previous encounters with the accused, we believe the crime may have been influenced by drug use or impairment. We would like to see Mr. Wilkins receive help with a possible addiction if possible. And that is all, Your Honor.
All right, thank you. Based on the representation that it's got a year in Eaton County still to come, I'm going to refer the $449.99 to collections. I'm going to waive any fines and costs in this matter. We'll waive the state fee also. So placing paramount on restitution in this matter for $449.99. I'll also waive the crime victims' rights fee. So Mr. Wilkins, when you're able to get out, and it'll be of the Eaton County Jail because your time served will be time served here, your sentence will be time served here, you should at least contact the city of Lansing to start making payments on the restitution on the $449.99 to the city of Lansing. It would be the City Rescue Mission.
That's correct, Your Honor, and I do have a pink sheet. I have shown it to Mr. Lee, and just for clarity purposes, it's $449.95. I misspoke earlier.
All right, thank you. All right, Mr. Wilkins, your time on this file is set. You should refer to the city of Lansing once you're done with your sentence in Eaton County. Anything else for the record in 22-02-865, Ms. Wilson?
Not for the people.
Mr. Lee?
Nothing further.
All right, Mr. Wilkins, you're all set. Thank you.
Ms. Shook?
Sure. Right, so we're on the record in docket 24-02016, 24-02110, and 24-02111. That is People of the State of Michigan versus Olivia Shook. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee for Olivia Shook.
And ma'am, you are Olivia Shook, is that correct?
Right.
Thank you. This is the time set for a pretrial on the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It sounds like Ms. Shook has some remediation measures that she needs to get to her attorney and is looking for some time to get a license. I believe this is going to be a request for an adjournment.
Okay, so it's a request for adjournment for compliance purposes?
That's correct.
Is that a fair statement of Mr. Lee?
Yes, it is, Your Honor. Your Honor, 2 weeks should be sufficient.
2 weeks should be sufficient. September 9th at 9:30. So this is adjourned for compliance on 240211. It's adjourned for compliance on 240211 to September 9th at 9:30. And it is adjourned for compliance to September 9th. September 9th at 9:30 on 24020016. Anything else for the record in either one of these 3 files, Ms. Wilson?
Not for the people, thank you.
Mr. Lee?
Nothing further, Your Honor.
All right, Ms. Shook, we'll see you on September 9th at 9:30.
Yeah, I'm sorry. I was gonna say, Mr. Jerome is on Zoom. I can talk.
All right. Has Mr. Goodrich talked to Mr. Drum? Or Mr. Lee, did you want to talk with Mr. Goodrich? Did you talk with Mr. Drum? Okay, so Mr. Lee, you're going to talk with Mr. Drum.
Yes, sir.
All right. All right, Mr. Drum, I'm going to put you in room 2, and Mr. Lee, your attorney will come and talk to you. All right, sir? You have to unmute.
Yep.
All right. So I'm going to assign you. You should get a prompt to go to room 2. We have Miss Porter.
Is Ms. Porter here?
No,
No?
I don't see Miss Porter.
Why don't we call her case?
Was she here previously?
Not that I'm aware of.
All right, so we're on the record in docket 24011795. That is people of the state of Michigan versus Michaela Porter. For the parties, please introduce themselves for the record. Ms. Wilson.
Abigail Wilson for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office here to represent Ms. Porter. However, Ms. Porter does not appear to be present today.
All right, so this was scheduled for 9 o'clock for pretrial. It's now 10:22. It would appear that the defendant has failed to appear for the pretrial. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. I'll be requesting a bench warrant with a 48-hour hold.
She's not, Ms. Porter's not in the Zoom courtroom or physical courtroom. Mr. Porter response, or Mr. Goodrich response.
Your Honor, we would just ask for the 48-hour hold, as this is a nonviolent offense and she does not have an extensive criminal history.
All right. I don't have any fail to appears on this matter. So I'll issue a bench warrant and bond forfeiture with a 48-hour hold. Anything else for the record in 24011795, Ms. Wilson?
Not for the people.
Mr. Goodrich.
No, Your Honor, thank you.
Thank you.
And then, Your Honor, since Mr. Stewart appears to have been released from custody, I'm guessing he didn't know he was supposed to be here today. I'm wondering if we should just reset that. Stu Stewart.
Sustor.
I swear I saw that flash across on Zoom.
Oh,
Oh, Mr. Lees wants to meet with Mr.
I've not seen him up here. Yeah, but that doesn't mean it didn't flash it.
I'll pause.
All right, Mr. Lee, I'm going to place you in a room with Mr. Drum.
Very well. Thank you, Your Honor.
You're welcome. And then Mr. Lee, were you ready on Mr. Drum?
Yes, Your Honor.
All right. All right, so we're on the record in docket 24-00790. That is the city of people, state of Michigan versus Brandon Drum. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee on behalf of Brandon Drum.
And sir, you are Brandon Drum, is that correct?
Yes, Your Honor.
You can hear me all right, Mr. Drum?
Yes.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding, or would you like to defer?
I would defer.
Mr. Lee.
Thank you, Your Honor. Your Honor, we're requesting a short adjournment, perhaps 2 weeks. Mr. Drum is going to pick up the ashes of his dog. He reports that the dog was impounded and subsequently put down. I have advised him that we will need to see some sort of paperwork to that effect, which he will collect when he gathers the ashes. So we're requesting a short 2-week adjournment so that he can gather those proofs, Your Honor.
All right, so this is, if he's no longer in possession, but we need some proof of that. Is that correct, Ms. Wilson?
Yes.
All right, so would be proof of compliance for deceased. We'll reset 2 weeks. September 9th at 10 o'clock. Right, we reset this for September 9th at 10 o'clock for proof for compliance purposes or that the animal is deceased. Anything else for the record in 24-00790, Ms. Wilson?
Not for the people, thank you.
Mr. Lee?
Not for the defense, Your Honor.
All right, Mr. Drum, unless you provide some type of proof or compliance, you'll be here on September 9th at 10 o'clock, right, sir?
All right, thank you.
Thank you. Is it Ms. Bazo?
Yeah, I don't know that she's here. It was set for a motion, but I think it was also set for a pretrial.
Yeah, I've got them both. All right, so we're on the record in docket 24-01703 and 24-01702. That is people of the state of Michigan versus Judith Bazo. Will the parties introduce themselves for the record? I'm sorry, I didn't. Who's on?
I believe it's Mr. Lee.
Okay, Mr. Lee.
Assistant Public Defender John Lee on behalf of Judith Bozo.
Bozo, all right. This is the time set for a pretrial in the matter. Ms. Wilson, how are we proceeding?
Thank you, Your Honor. It doesn't appear that Ms. Bozo is here. Let's set for a pretrial and a motion. I would defer to the defense.
Mr. Lee.
That is accurate, Your Honor. I have not seen Ms. Bozo today. I have been in contact with her, although I am not aware of her reason for not being here this morning.
All right. This was scheduled for 9:30. It is now 10:33. And the defendant has failed to appear for the pretrial and or motion. I'll issue, because of the nature of both offenses, I'll issue a bench warrant and bond forfeiture with a 48-hour hold. Anything else for the record in 24-01703 or 21-01702? Ms. Wilson.
Not for the people, thank you.
Mr. Lee.
Nothing further, Your Honor.
All right, that's all for the record in those two files. That leaves us with Mr. Wirt.
Yes. Yeah, he didn't show up, so we just reset it because he was released and I don't get notice.
That was, yeah, that we reset Mr. Sustor. Did you need to speak with Mr. Wirt?
Is he here? Yeah.
He's right there.
Yes.
All right. So,
I haven't offered mine, but I need to do some research on the restitution because it's weird. So adjourn it, yeah.
Sorry, Mr. Wood, I didn't- Yes. Yeah. Yeah, I heard that. Oh, yeah, yeah. Yep. No, it's all good. Your team's working.
Yeah.
they just want to check the camera to make sure it's
That's a David problem.
Mhm.
We have to adjust the camera on the jury box on Zoom. I can give you the remote so you can mess with
Oh, okay, yeah.
it. Because yeah, no, it's the silver one.
We'll worry about that when we go, but
Worst
yeah.
comes to worst, tell them thank you.
Well, you,
He's gonna call you. when he calls you.
You just have to take it off the jury box and put it in the judge.
all right, so we're on the record in docket 23-00593. Mr. Wirt, you can come over here. That's people of the state of Michigan versus Andrew Wirt. Will the parties please introduce themselves for the record? Ms. Wilson.
Abigail Wilson for the people.
Mr. Lee.
Assistant Public Defender John Lee appearing on behalf of Andrew Work.
And sir, you are Andrew Wirt, is that correct? Thank you. This is the time set for a pretrial in the matter. Ms. Wilson, how we proceed?
Thank you, Your Honor. I believe that this is going to be a request for an adjournment. I have a potential offer in mind. However, I'm not sure as to the restitution and I want to look into that before I relay it.
Is that a fair statement, Mr. Lee?
Yes, it is, Your Honor.
So we'll adjourn the matter essentially for negotiations to continue, but also we have an open question as to the amount of restitution. And what's the time frame that we're looking at, Ms. Wilson?
I would request 2 weeks.
Okay. So 2 weeks out, and then we have a writ.
Yeah,
So you might want to do maybe a little further.
we have 2 weeks for 4 weeks.
Let's try 2 and see what happens.
I'm at 10 o'clock.
All right, so we've rescheduled this for September 9th at 10 o'clock, but we'll prepare the writ from Eaton County and then cross our fingers on some level.
Yeah.
But that should give us enough time. Anything else for the record in 23-00593, Ms. Wilson?
Not for the people. Thank you.
Mr. Lee.
Nothing further, Your Honor.
All right, Mr. Wirt, you're all set. Thank you for your appearance today. All right.
Nathaniel's on his way up.
Daniel's on his way up. What does that mean, David?
Nothing good.
No button I pushed worked, so,
Well, it's fails found the fail.
yeah.
You mute
All right.
us since we're in.
Yeah, let's go ahead and-
Mute us.
David Warnsley is my court officer. David picked the wrong day to come to work because he is serving as my court officer. He's Judge Buchanan's court officer. He's mine today. My court officer is sick. Okay. So, and we're better off that she's not here because she'd be making us all sick. This is a criminal case involving the accusation or charge of child abuse 4th degree, which I'll explain more fully later. This charge has been made against the defendant, who is William Strong. The defendant's lawyer is Tara Nickel. Please introduce yourself, Ms. Nickel.
Morning, ladies and gentlemen. Thank you very much for coming to serve as potential jurors. I am Tara Nickel. I have the privilege of representing Mr. Strong today for the jury trial. Thank you very much.
Thank you, Ms. Nickel. The lawyer for the state of Michigan is Assistant Prosecuting Attorney Abigail Wilson. Ms. Wilson, you may introduce yourself.
Hi, everybody. Thank you for being here. My name is Abigail Wilson, or Abby Wilson. Thank you all for being here, and I represent the state as the judge said.
Thank you. The witnesses who may be called by the people of the state of Michigan in this case are Jason Alamsi Strong, Officer Jonathan Bynum, Jaden Strong, Detective Jason Punk, Sawisha Porter, Elizabeth Panic, Officer Ethan Merlick, and Jamie McCarthy. Does anyone in the jury box or waiting to be chosen know the defendant or any of the lawyers or witnesses in this case? Okay. We think the trial will last about a day. All right. If you believe the length of the trial will be a real hardship for you, please let me know right now. Is there anybody who can't donate a day of their time to this cause? All right, ma'am.
I'm a school bus driver.
So you'll have to state your first name and last name for the record. Okay.
I'm a school bus driver, and we don't really have the subs to cover my route, so that would cause 66 kids on my bus to find a way home.
Right. And did you bring this up prior to this event right here? Did you call anybody? Did you let anybody from the civil department of 54A know, or the criminal department? All right. Well, let's see how things work out today. Okay. All right. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? Does anybody have a medical problem like that? Does anyone have a sight or hearing problem? I don't know what this means. So what's your name for the record,
I
ma'am?
can't really see that far away.
All right. And what's your name?
Chloe Stanton.
Okay, Chloe Stanton. All right, we'll keep that in mind. You may be our first juror, so you're closest to the witness, but let's see how things turn out, okay? This is a criminal case. The paper used to charge the defendant with a crime is called a complaint. The complaint in this case charges the defendant, William Strong, with the crime of child abuse in the 4th degree and reads as follows. On or about December 17, 2023, at the offense location of 2915 Delta River Drive, City of Lansing, Ingham County. In count 1, William Strong is accused of knowingly or intentionally committing the following act or acts that under the circumstances posed an unreasonable risk of harm or physical injury to a child by grabbing, pulling the child down onto the hard floor and ripping his jacket. That is the allegation. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you're satisfied beyond a reasonable doubt that he is guilty. So the presumption of innocence starts before the complaint's filed, and it follows until deliberations. Do you understand that? Okay. Every crime is made up of parts called elements. The prosecution must prove each of the element crime beyond a reasonable doubt. The defendant is not required to prove his innocence or do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. As your name is called, please come forward and take your seat in the jury box, starting in the back row with the seat closest to the back of the courtroom and filing in across the back row, then the front the same manner. So it'll be juror number one will be the furthest. So you have to, so you're gonna end up climbing over one another is what I'm trying to warn you about, okay? But you'll have to go all the way and you'll start where David is and you'll go in and we'll start juror 1, 2, 3, 4, 5, 6, 7. We're gonna pick 7 of you, okay? All right. So I just told you the easy part. Now you're gonna be climbing all over one another. The juror number 1 will be Eleanor Richards. So Ms. Richards, if you come this way and you go all the way around, because we don't give you a door on the other end. Juror number 2 will be Susan Lamoth. Right, Ms. Lamoth, the same for you. Juror number 3 will be Danae Bennett. Right through there and around. Ms. Bennett, thank you. Juror number 4 will be Sergey Kitching. Juror number 5 would be Stephen Palmer. Juror number 6 will be Aurora Cullerton. And juror number 7 will be Mark McKenzie. All right. So for this voir dire proceeding, you've heard all the questions I asked previously. Ms. Lamoth, you indicated that this might be a hardship for you. So the attorneys are aware of that and they'll ask questions accordingly. And then you've all indicated that you don't have any health problems that would keep you from sitting 2 or 3 hours. All right, we'll start with the assistant prosecutor, Ms. Wilson. You may ask the voir dire the questions.
Thank you, Your Honor. Before I begin, I just want to make a brief record that I did ask Mr. Warner where to put some of my witnesses. I did not say the names or anything, but the jury might have heard the word witnesses.
All right.
Okay. Thank you for being here today. Does anybody here dislike public speaking? Yeah, I do too. It's my job. I don't know why I did this, but here I am. Now, for those of you that don't like public speaking, how many of you don't like it because you're afraid somebody might judge you? No? Yeah? Anybody else? Yeah? Okay. So I can tell you right now that this is a judgment-free zone, okay? And I know that sounds kind of cliche, but it is. And what we need here today is honest answers, even if you think maybe, oh, maybe it kind of makes me look bad or it's not great. Honest answers are really important to make sure that everybody has a fair and impartial trial. So can everybody promise me that you're going to try to be as truthful as you can today?
Yes.
Yes, perfect. Okay. So has anybody lived in Lansing their entire life? No? Miss Richards, where else have you lived?
I've lived in Boston, New York, and Chicago.
Okay. What about Miss Bennett?
Haslett,
Oh, Haslett, okay.
Fowler.
Anybody live in Ingham County their entire life? Yeah, all right. Now, does anybody have any religious or moral objections to sitting in judgment of another person? No? Okay. Now, has anybody ever been involved with the criminal process before, either as a victim, a defendant, a witness, or a juror? I'm a juror. Okay, what kind of case was that?
It was when I was in Boston, so it was like 10 years ago. Somebody left a gun on a roof, and there were these two young guys that were in the parking lot. And they were being accused of that being their gun, but it was on a roof far away from them. So I
Gotcha.
thought it was a little-
So kind of, it sounds like
Yeah.
maybe you guys returned a verdict of not guilty in that case?
Yes, although I
Okay.
was actually chosen as an alternate, so I stayed on through the whole thing. And then when they actually finally went in the room to pick, they drew my name out of a hat and made me sit in another room.
Gotcha. That brings up a really great point. So we have seven of you here today. Only 6 of you will actually end up going into deliberations. The reason that we have 7 of you is in case something happens. God forbid somebody have some kind of medical emergency and they needed to go to the hospital or something. We still have an extra person that can sit and deliberate. So thank you for bringing that up. That was a really great point. Anybody else ever been involved in a criminal case? Sir.
Assault charge into.
Okay, was that in Ingham County? No. Sorry, say again? Ottawa County. And what was the result of that, if you don't mind me asking?
Charge dropped.
Charges were dropped. Did it end up going to a trial? No, okay. How do you think your experience with that was? Terrifying. Okay. Do you think that your experience there might influence your ability to make an impartial decision here today?
No.
No, okay. Has anybody had a family member or a close friend be involved in the criminal process before? No one? Okay. Anybody have any experience with Child Protective Services?
Yeah, it's my work position.
Oh, you're a registered nurse, so you're a mandatory reporter. Okay, can you tell us a little bit about your involvement with criminal protective or Child Protective Services?
Yes, one case I managed as obviously the child that was involved in the automobile accident wasn't being cared for by the parent.
Gotcha. And so was your role in that one of the referrals to Child Protective Services?
Sorry.
Okay. Was there any sort of court process that you had to be involved in as part of that?
No.
No, okay. So there is some Child Protective Services involvement in this case, and you might hear from the worker in this case. You might not, it kind of depends on how the proofs come out. Does anybody think that if someone is charged with a crime but not yet found guilty of it, they're guilty anyway? No. Miss Cullerton, have you ever heard the phrase presumption of innocence?
I don't think so.
No? Okay. In hearing that phrase today, do you have an idea of maybe what it might mean?
Basically innocent. Sort of thing.
Great, yeah. So the defendant in this case, Mr. Strong, is innocent until I prove my case. I have the burden here. I have to prove the case beyond a reasonable doubt. If I don't prove my case, then he remains innocent, not guilty. If I do prove my case and you decide at the end of my case that he is guilty beyond a reasonable doubt, then you can enter a verdict of guilty. Does anybody have any questions about that? No, does anybody think that they might have a problem with that? No? Oh. So let's talk about beyond a reasonable doubt. Has anybody heard that phrase before? Can you describe a little bit for me? Okay. And when you say any doubt, does that mean any doubt in the universe? No. What kind of doubts do you mean?
Anything hasn't been proven
Okay,
completely, you know.
gotcha.
If there's
So-
any questions about something.
That's a great point. So sometimes, a case will end and you'll have some questions about it. Now, the judge is gonna instruct you later about what we call the elements of an offense. And those are the things that I have to prove in order for you to find someone guilty. Not all of those things or all of those things should be proven, but you might still have some questions at the end. One of the most common examples of this is motives. Has anybody ever had an experience with someone where they acted super outrageous and you just had absolutely no idea why they were doing it? Yeah. Can you tell me a little about it?
Just like, yeah,
Yeah.
well, my ex was very aggressive.
Okay, gotcha. Yeah. Does anybody kind of follow the news? Yeah. Do you see any like criminal cases and headlines?
Yes.
Okay, in any of those cases, have you seen anybody found guilty?
Yes.
And at the end of that, have you ever been left wondering, well, I still don't know why they did it?
Yes.
But do you think that they still did it? Depending on the case.
Well, yes, some things are subjective. But
Right, yeah. Okay, so even if you're left with that question of why, you still think that maybe they did the actions that make something a crime?
I'm sorry.
Sorry, it was a poorly worded question. So let's say you have a case and you think that the prosecutor in the case has proven every element beyond a reasonable doubt, but you're still left with the question of, well, I don't know why they did it.
Didn't have a motive.
They didn't have a motive. Are they still guilty of that criminal offense?
Probably less. I mean, it would be like a difference between murder and manslaughter, right?
Okay, yeah, that's a good point. Yeah, so one of the things that we're gonna kind of talk about is the legal jargon is the mens rea. You guys don't really need to know that part. Really, it's the state of mind of the person. Is anybody here a mind reader? No, great. So can anybody think of ways that they might infer someone's intent of something? Mr. Kitchen, can you think of anything?
Could you repeat the question?
Yeah, so in your everyday life, are there ways that you're able to determine somebody's state of mind or their intent?
Not necessarily.
Not
Unless
necessarily.
they're physical actions.
Okay, so you can surmise it from their physical actions.
Yes.
Okay, what about their words?
Occasionally.
Sometimes, okay, great. So those are all things that you're allowed to consider when you're considering somebody's state of mind. Does everybody understand that part? Yeah, anybody have an issue with it? Anybody? Yes?
Does that include something like what they may or may not have to gain?
It could be, yeah, definitely.
Action.
Yeah, it could be, yeah. Yeah, if somebody has something to gain, that could definitely be something that you consider, absolutely. Yeah. Does anybody think that they would require some kind of crystal ball in order to determine beyond a reasonable doubt somebody's state of mind? Yeah, so if I can prove, so let me back up. Is there anybody that thinks that unless they have some kind of crystal ball that magically sees into somebody's brain, they will not be able to determine somebody's state of mind?
I think we can without a crystal ball.
Okay, great.
That's what you're asking.
That is what I'm asking,
Okay.
yes. I apologize, yes. Sometimes I know what I'm saying and it doesn't come out correctly. Yes, thank you. Anybody else agree? That you don't need that crystal ball to see somebody's state of mind?
Rather elements to that.
Yeah, mhm,
Facts.
yeah, facts that you can infer it from. Yeah, anybody disagree? Depends, okay. And is it fact specific?
Yeah, and I think somebody can have different intentions than what they end up doing.
Okay, yeah, that's a good point.
Yeah.
So maybe they go into a situation with maybe good intentions and they end up doing something wrong. Okay, yeah, that's a good point. In that situation, would you still be able to look at the circumstances surrounding to infer what their intent was?
The original intent?
The original intent or even the intent later? Sort of, okay. Anybody a fan of crime shows or crime books? Law and Order, CSI, anything like that? Yeah,
Law and Order.
Law and Order, okay, any specific Law and Order?
Law and Order marathons.
Oh, okay, because I know there's like,
It's been a while, but
oh, it's been a while, okay, because I know there's like the original and SVU and stuff like that. Original, okay. So in those episodes, if you remember, what kind of evidence do they usually have?
all physical evidence.
Okay,
Eyewitness testimony.
okay. Do they sometimes have like some really elaborate scientific evidence to describe something?
CSI stuff.
Yeah, like CSI stuff. Yeah, if I told you that CSI isn't involved in every criminal investigation, would you be okay with that?
As long as it's not all eyewitness testimony.
Okay, I gotcha. So you want some kind of corroboration for the testimony?
I would prefer that. Yeah.
Okay, and do you want that in the form of something like laboratory results, or can it be something like I'm sorry, I'm blanking. Can it be something like a scratch mark or something like that?
Physical evidence definitely helps. A timeline.
Okay.
Something logical. Something.
Okay, gotcha. So does anybody think there's a specific amount of evidence that's needed in order to prove a case beyond a reasonable doubt? No?
Like any of these?
Like, is there like a magic number?
Or more than zero?
More than zero? Okay, yeah, understood. Yeah. So let's say you have one witness, only their testimony, and you believe everything that they say beyond a reasonable doubt. Is that enough? No? Okay. So even if, are you saying that it wouldn't be enough because you wouldn't believe just one person's testimony?
I don't believe it's reasonable.
Okay, I got you.
Like you said, that's where how.
Okay.
How do you juxtapose those two?
Okay, yeah, I got you. Anybody think similarly?
I guess it depends on how strong the evidence is.
Okay, gotcha. All right. Does anybody have any kids? You, sorry, say again?
He's a 30-year-old now. But
Gotcha.
I always think,
Yeah, my parents still think of me as a kid. And so when they were kind of a little kid, did they ever kind of cause some mischief?
Yeah.
Yeah. Did you have typical like discipline tactics that you used when they did that?
once in a while, just tell them that they got a timeout.
Okay, so timeouts,
Yeah.
gotcha. Now, when you were talking with your child, did you ever talk to them about like how their day went?
Yeah.
Yeah, and did they remember everything in chronological order when you were talking to them? No, but how did they kind of relate it to you?
Oh, just usually it was recess.
Okay.
Start with that. Yeah.
So the stuff they kind of thought was important.
Yeah.
Okay, I gotcha. So the judge said that the charge in this case was child abuse in the 4th degree. Mr. Kitchen, what do you think of when you hear the word child abuse?
Causing physical or psychological damage.
Okay, gotcha. Does it always have to result in some kind of physical or psychological injury?
Not necessarily. I think it
Kind of depends on the
just depends on the
facts.
situation.
I gotcha.
Yeah.
Yeah.
It's kind of a,
Anybody think that in order for there to be child abuse, there has to be some kind of injury?
No.
No? Okay. Alright. Now, does anybody have any thoughts or concerns that they think would be important for us to know about your ability to sit on a jury today?
When I was married,
Mhm.
I was abused as a wife.
I got you. Okay, I'm sorry to hear that. So you look like you're struggling to kind of talk about it. Is it still emotional for you?
Yes.
Definitely, yeah. Okay, did you ever go through the court process because of that?
I did.
You didn't? Okay. Now, some of the testimony that you might hear today is obviously about abuse. Is that something that would be so triggering for you, you wouldn't be able to like concentrate?
It might be.
It might be. Okay. Do you think your prior experience with abuse might cloud your ability to look at the evidence? It might. Okay. All right. Well, thank you very much for sharing that with us. I know that was probably difficult. All right. I have nothing further at this time, Your Honor.
Ms. Nichol?
Thank you, Your Honor. Prosecutor talked about her burden and the presumption of innocence. I want to start talking about that for a minute. Does everybody know what a map of the United States looks like? Okay. If you saw a map of the United States and it didn't have the names on it, would anybody have doubt that that was still a map of the United States? No? Why not? Mr. Palmer, why would you still believe it was a map?
because it looks like the United States. I'll be honest, I feel pretty uncomfortable with this. I'm not really good at answering questions and stuff. I'm sorry, but
That's all right. So, Mr. Humber, what if I showed you a map and I told you it was the United States, but I took away Florida and Maine and Texas? Like you couldn't see those shapes anymore. Would you still think it was a map of the United States?
yeah, Florida. Yeah.
Would anybody else have doubts that it was no longer a map of the United States?
I would,
Yes? Why would you have doubts that
because
that's
we're missing. I mean, like, it's not the US, because I know what I've looked at all my life, and that's not the shape of it.
Before we started jury selection, everybody said that they did not know Mr. Strong prior to today. That's correct? So at this point, would we all agree that we don't know what Mr. Strong is seeking at any particular point and don't know him well to make that determination as of right now? Everybody agree with that? Prosecutor talked about some of the evidence that you might see and things you may not see. If I took this pen right now and I dropped it, and somebody asked you tomorrow if the defense attorney dropped a pen, would any of you have any doubt that that's true? And would you all agree it's because you actually saw me drop the pen? Now, what if I went into the hallway and somebody told you that I dropped the pen? Would you be less sure or more sure that it's true? Less. Why do you say less?
Because I didn't see it personally.
You didn't see it first. Okay. Does anybody else have something different than Mr. McKenzie on that? Yes,
I guess I would consider it to be hearsay.
hearsay. Have you heard that term before in a different trial? Okay. And when you say that word, what does that mean to you?
It's not something you actually saw, you just heard it from another source.
I know only Mr. Palmer mentioned that he had a child that was younger. Does anybody else remember their parents discipline them more than just timeout or anything like that? Yes? What did your parents do beyond just like timeout or anything like that?
Isn't that when I was a child?
When you were a child?
Yeah, we got a spanking.
And was that something that you were aware of if you did something that was coming?
It was very few, maybe twice, just to be told that it was coming.
Okay.
And this never happened again.
That's okay. Anybody else had their parents spank them as part of the discipline at all? Yes.
I had my mom, when we were bad, she hit us with the yardstick.
Okay. And that was something that happened a lot?
Not a lot,
Not a lot?
but enough to make sure we do whatever we did. Yeah.
Yes.
And then maybe like once or twice, I could say, but it was very, very rare.
Very rare? Okay.